There are a number of sources for school law that you need to be aware of. Along with what is listed on the screen, please make sure that you understand the importance of the 10th Amendment. The 10th Amendment is often called reserved powers of the state, and it is the reason that the federal jurisdiction over schools is fairly limited, while the states are the primary source of all governance for public schools. This amendment authorizes the states to set up local school boards, etc., which happens in the state constitutions. From another view, make sure that you understand the terms dealing with the different levels of constitutional law. So we have statutory law, we have administrative law or administrative regulations, we have constitutional law or case law. We use the term contract law, which is very important in schools in terms of our relationship with our employees, and judicial decisions, which is the body of case law, both federal case law and state case law. The U.S. Constitution really does not mention education, but in the 20th century, we have seen a ever-growing expansion of federal power over schools, and that is because of a number of clauses that exist in the U.S. Constitution. And as education has become increasingly important, as our country became industrialized, and through the 20th century, global issues begin to affect our ability to function as a nation, the federal government has taken more and more interest in the education of its people through the General Welfare Clause, for example. The federal government has felt a duty to oversee the state's jurisdiction over education. Other articles that have expanded some federal power in education is the Commerce Clause, for example. This clause allows for some indirect support, particularly through funding. The NCLB law, for example, which provides funding to, federal funding to local school districts. And of course, that funding comes with strings attached. So in order to continue to receive federal funding, local school districts must maintain certain standards of education. Also make sure that you understand the role of the 14th Amendment in particular when we are talking about the role of the federal government in local school districts. The 14th Amendment includes phrases that ensure that state governments must provide due process, for example, to all citizens, and equal protection to all citizens. And again, in the 20th century, that amendment has been used to ensure that all citizens of all states are protected under the Bill of Rights, the first 10 amendments of the U.S. Constitution. So the 14th Amendment became a vehicle through which the Bill of Rights, which originally did not apply to states in terms of their relationship with their citizens living within the state, it only applied to the relationship between the federal government and individuals. But through the 14th Amendment, that changed in the 20th century. So today, schools, which of course, public schools are government officials, and if you work for a public school, you are a representative, an agent of the state government in that capacity, must uphold and must ensure that all of the Bill of Rights are upheld in terms of your relationship with those individuals, the parents and the students who attend your school. Other important amendments, obviously the First Amendment through the 14th Amendment applies to all relationships between public schools and the students and parents that attend there. This includes free speech, the separation of church and state, the Establishment Clause, free assembly, the Fourth Amendment, which denies unreasonable search and seizure. Eighth Amendment, cruel and unusual punishment has been used to question corporal punishment in schools, for example. The 10th Amendment, which we've already identified as the reserved powers, which give the state then control over the schools. And of course the 14th Amendment. There are others, less important, but still have been brought up in terms of public school relationship with students. Personal privacy, for example, is implied in the 9th Amendment. 13th Amendment, which denied enslavement, has been brought up in terms of service requirements in public schools, for example. So less important, but there are other amendments that become important as we look at school law. Terms that it is important that you understand: statute versus regulation. A statute is a law. It is made by a governing body, a legislature. A regulation at both the federal and the state level refers to a agency that exists because the legislature created it. So the legislature, for example, might pass a statute that gives a very broad but not very detailed or defined authority to an agency, and then that agency's job is to create the details of the regulations that uphold that broad defined statute. So these exist both at the federal and the state level. Some important federal statutes, and again, these are important for you to know both in terms of this class as well as important for you to know as an administrator. You will need to be able to have a working knowledge of the IDEA, of the child abuse reporting of Title IX, Civil Rights Act, both Title VI and Title VII, No Child Left Behind Act, as well as the ADA. In terms of administrative law, these are the regulations that really provide the details that govern our school on a day-to-day basis. And this, depending on the state that you're in, might be just as true for private school administrators as it is for public school administrators. So for example, in the state of Nebraska, the Board of Education, which is created by statute in the state legislature, has created a series of rules that are applicable to all schools in the state of Nebraska. Rule 10, for example, for all accredited schools in the state of Nebraska, whether we are private or public, we must uphold the regulations if we are accredited in the state of Nebraska. So other states have different sets of rules for private and public schools with much fewer regulations, and again, that varies from state to state. Make sure that you understand the difference between a state court and a federal court and what kind of cases would go to these different courts. That really depends on both the standing, in other words, who is bringing the case to the court, as well as the question that is placed before the court. So for example, if the person bringing the lawsuit is a student and their family who is charging negligence by a teacher, that is a state court question and something that would be adjudicated through the state court system. In a federal court, however, would be the question of a school board denying basic civil rights to a student or a group of students, because that would be under the question of the Bill of Rights through the 14th Amendment in terms of the federal government's relationship and to the state government's relationship through a U.S. Constitution. So those are two examples of cases that would go directly to the state courts and be fully adjudicated in the state courts would be questions of negligence, where questions of civil rights would be adjudicated in the federal court system. In the state court system, there is a hierarchy of courts. The trial court or the circuit courts are the original jurisdiction for almost all questions that go before state courts, and that is where most legislation actually, or most cases are actually go through the circuit courts and stop there. If the side that does not win in that original jurisdiction, that original trial, appeals to the appellate court, then it would move up to the appellate court, and then it can also go to the state Supreme Court. There are a few exceptions to that. There are some questions or some individuals with standing that would have original jurisdiction, for example, in the state Supreme Court. So some cases do go directly to the state Supreme Court, but not many. The vast majority would go directly to the trial court and then can be appealed beyond that. There are also some special courts, labor relations courts, for example, where if there was a dispute between a union and a school district, it might go through a special court. The federal court system, of course, is very similar, pretty much mirrors what exists in the states. So at the district court level, we have a original jurisdiction. This is where most trials occur. The Circuit Court of Appeals is only appellate jurisdiction, so there's no arguments that happen in an appellate court. It is a panel of judges whose job it is to review the records of the lower court and decide if the procedures were followed and if the reasoning of the judge was sound, and thus uphold the lower court's decision or overturn the lower court's decision. The U.S. Supreme Court exists, and again, much like the state Supreme Courts, there are a few cases that can go directly to the Supreme Court, not very many, but it would depend on the standing or the question, but most would go through that hierarchy of courts in order to be fully adjudicated, or would not be allowed to be appealed on some technicality. Supreme Court justices, as you have probably noted, we have had a recent change with the appointment of Neil Gorsuch, and I hope that as you read through the chapter, as you make your way through school law, that you understand that that will affect decisions of the Supreme Court. The leaning of the Supreme Court has changed, and that will have consequences for both public and private schools in terms of the kinds of decisions that are reached by the Supreme Court, and thus the law that as it applies to our schools on a number of issues that are going to be big questions for the next few years. And to end our chapter, just a little bit of justice trivia. Maybe not trivia, some of it's kind of important and things that you probably ought to know. Who's our Chief Justice? How are justices appointed? For how long are they appointed? Why is it important for you to know about members of the Supreme Court? So if you have questions about this and anything else, always feel free to reach out to me and ask questions. I am always here for you.